Hello, and welcome to Crime in Court. My name is Heather, and I have a new docs from Delphi. So much is going on with this case. It is daily that I've been doing an update because there have been things going on daily in this case, pretty much, as at least it seems that way to me. All right, so let's dive into the latest motion from Richard Allen's attorneys. This is a motion to dismiss for destroying exculpatory evidence. Basically, the title is self-explanatory, so let's see. They want to dismiss the charges based on evidence that they claim has been destroyed, or in some form or fashion, it's missing. So here. Comes now the accused Richard Allen by and through counsel Andrew Baldwin and Bradley Rosie, and pursuant to the 5th, 6th, and 14th Amendments to the United States Constitution, Article 1, Section 12 of the Indiana Constitution and Code whatever, A11, moves this court to dismiss charges against the accused for destroying exculpatory evidence in violation of the standards set out in Brady versus Maryland. And that is like the standard case that they always refer to when there's exculpatory evidence that's not being handed over, usually on purpose, or was missed, by the prosecution or whatever. So if exculpatory evidence exists or is presumed to exist, then you need to, according to the standard, drop the charges. So in support of said motion, the accused states the following. Richard Allen stands accused of murdering 2 victims on or about February 13th, 2017. Since receiving discovery on this case, the defense has unearthed significant evidence that third parties named Brad Holder and Patrick Westfall were involved in the murders. That evidence is critical to the theory of defense. And if you are, if you're just finding me now, I'm actually doing a reading of the Frank's memorandum. I just recorded part 7. There's probably going to be about 8 or 9 parts. Probably 9 parts. But anyways, so we're reading through that, and it is very clearly talking about the defense's strategy as to why Brad Holder and Patrick Westfall, these 2 other individuals that were local, had more there was a lot of reasonable doubt towards these individuals that they were the ones that committed the crimes rather than Rick Allen, and Rick Allen has no connections to these people whatsoever. So, all right, so number 3, the defense would incorporate into this motion the contents of a Frank's memorandum that was filed with the court on September 18th. So that's what we were reading, which provides the details of the evidence that supports Brad Holder's and Patrick Westfall's involvement in the unalivings. In discovery, the defense found a document dated February 17th, 2017 that appears to be an FBI report memorializing an interview of Brad Holder. Contained within the document are these words. The below is an interview summary. It is not intended to be a verbatim account and does not memorialize all statements made during the interview. Communications by the parties in the interview room were electronically recorded. The recording captures the actual words spoken. So, what does that mean? They found in their discovery somewhere a reference to recorded interviews with these individuals. So moving on. Also in discovery, the defense found a document dated February 19th, 2017 that appears to memorialize an interview of Patrick Westfall. The report itself does not indicate whether the interview was recorded, although the defense would expect that standard procedure would require video and audio recordings of all statements. After locating this document, the defense sought a copy of the recording detailed in the February 17th, 2017 report so that the defense could listen to the exact spoken words of Brad Holder during his interview. This is vital to Allen's defense, particularly the statements that the author of the document admits were not memorialized in the document. So, back to that quote, they memorialized the interview by writing a summary. However, not all statements that were made during the interview made it into the summary, is what this quote is saying to me, and that's what they're picking apart. So number 7, also, the defense requested a copy of all audio-video of Patrick Westfall's interview that was memorialized in a February 19th, 2017 report. On September 8th, which was a big data dump that they gave, the prosecution gave Allen's team, and that would be 4 months away from trial-ish. So, yeah, why were they getting this big data dump that obviously the attorneys would have to go through and figure out what is relevant to their case? So it almost seems like it could have been a tactic. But anyways, that's my opinion, and moving on. On September 8th, the prosecutor communicated in a letter that there were no audio or video interviews of Brad Holder or Patrick Westfall available. Prosecutor McClelland offered no explanation as to why these didn't exist. So what happened to the videos? You said there were videos, which captures the actual words spoken, and then now we come to a few years later and there's no audio or video of that, of those interviews. So before the defense had an opportunity to investigate the reason why these material pieces of evidence were not available, Prosecutor McClelland called for the disqualification of attorneys Rosie and Baldwin as Richard Allen's lawyers. Judge Gull, without a great deal of hesitation, said she was leaning towards granting McClelland's request. Ultimately, Judge Gull caused Rosie and Baldwin to be taken off the case. This occurred before Baldwin and Rosie learned of why crucial videotaped interviews were missing. So they were kicked off the case before they ever even found out that this information was gone. On January 31st, after being reinstated to the case, the prosecution turned over discovery to the defense, including a letter cataloging the evidence that the prosecutor was turning over. Contained on page 5, paragraph 5 of the itemization of discovery are these words that explain Brad Holder's missing videotaped interview and Patrick Westfall's missing interview, if one existed. Quote, due to a DVR program error discovered on 9/20/2017, all recordings up to February 20th, 2017 were recorded over. There is no detectable audio found on this drive, end quote. So that's convenient because that's when they were being interviewed. Brad and Patrick were interviewed during this very short window, February 14th through the 20th, within days of finding the girls. So they were suspects immediately, going forward from the immediate investigation. They were suspects and interviewed by police, but somehow their interviews got wiped clean. The video interviews were deleted by the police. It is unknown, that's the defense saying that, I'm not saying that. It is unknown what other interviews are deleted during the relevant time frames. The destruction of material interviews of key suspects early in the investigation demonstrates negligence, if not intentional conduct on the part of the state. How could law enforcement, while investigating the most serious of crimes, record over interviews of material suspects with recklessness or intentionality? Either way, it's not looking good for the law enforcement who did that. All right, so as a material part of his defense, Richard Allen is expected to direct the attention toward Brad Holder and Patrick Westfall as being involved in the unalivings of these two young victims. The evidence will also show that Richard Allen does not know Brad Holder or Patrick Westfall, and therefore Richard Allen had nothing to do with the unalivings. This destroyed videotaped interview of Holder and Patrick Westfall, if it ever existed, was expected to contain evidence that could provide exculpatory and material evidence in support of Richard Allen's defense. Sorry, my dog kicked the laptop stand. All right. If recording of Westfall was never secured, that too is a purposeful or neglectful failure to preserve material and exculpatory evidence. Basically, they're calling them out as negligent. If not negligent, then they did it intentionally to get rid of that evidence, because it is key witness evidence, key, what did he call it? I don't remember. But it is, they provide exculpatory evidence in the sense that because these two are considered suspects, it takes the heat off of Richard Allen. If a recording, where did I leave off? This destroyed videotaped interview of Holder and Patrick Westfall, if it ever existed, was expected to contain evidence that could provide exculpatory and material evidence in support of Richard Allen's defense. If a recording of Westfall was never secured, that too is purposeful or neglectful. So if they didn't record the interview from Patrick Westfall, which we don't know because we'll never know now, because somebody messed with the evidence. So it's interesting. There's just too many things going on in this case that make you go, to really think that Richard Allen is the guy. I don't know. What do you guys think? Let me know in the comments below, please. I always forget to say, please like, comment, subscribe. It really helps with the algorithms. It helps let YouTube know what kind of videos you like and what topics you're interested in. So it's beneficial for all of us if you like that video. All right. So all right, moving on. Experienced defense lawyers fully understand the significance of comparing and contrasting the accuracy and credibility of one's video/audio taped statement with that information which is represented by law enforcement officers in police reports or summaries. It is through this process that Richard Allen would have been able to challenge the veracity of the statements of Holder and Westfall. However, the state's intentional or negligent destruction of the original recordings deprived the accused of such an opportunity. He can't defend himself because he can't view it. The state's actions have deprived the defense of the ability to compare Brad Holder's words from February 17th, 2017, only 3 days after the victims were found, to the evidence that was unearthed over the next several weeks, months, and years. This would have allowed Richard Allen to determine whether Holder's story was consistent with unknown evidence at the time of Holder's first statement, and whether it is consistent or inconsistent with future testimony, be that trial testimony or deposition statements or testimony made to other persons or witnesses. So it's a great point. You can't go back and compare, and you can't impeach the witness on the stand with his own words because you don't have them. You only have a representation of what the police officer said happened in that interview, and that's his interpretation of it. So you cannot find it reliable because everyone has their own biases. And that's why recordings are so important. In any criminal investigation, the interviews of potential witnesses must be preserved, such as the precise words of Holder and Westfall in their 2017 interviews, because an additional information is developed. As additional information is developed, reviewing prior statements may reveal inconsistencies or raise questions about other witnesses or other information relevant to an unbiased investigation. Without the actual audio video that would provide the exact words spoken from Brad Holder's mouth, the accused Richard Allen will never ever be able to know exactly how many inconsistencies existed in the original statements of Brad Holder and Patrick Westphal when compared to the evidence that was later discovered or future testimony of Holder and Westphal. Nor can Richard Allen challenge the credibility of Holder and Westphal in light of subsequently discovered evidence. All very good points. Furthermore, Allen is deprived of the ability to confront either suspect with their own words, contradicting any self-serving testimony they may offer throughout the investigation or prosecution. On August 30th, 2023, following depositions in which the state of Indiana and law enforcement learned that the defense believed Brad Holder to be an actor in the unalivings, law enforcement finally re-interviewed Holder for what is believed to be the first time since 2017. So they never went back to him until August of 2023. And it looks like they only did that because of depositions or something that happened in the depositions. Because they learned that the state of Indiana believed that Brad Holder was involved. All right, within those depositions. So that makes sense. But that doesn't make sense why he was interviewed in 2017. That got lost, and now the next time he was interviewed is in 2023. While in 2017, according to the memorialized report, Brad Holder told law enforcement that he never met Abby Williams, who was purportedly dating his son. There's a footnote. Holder never actually met Abby himself, and that's coming from the report. His story changed in 2023 when he talked to law enforcement. In 2023, Holder told the interviewer at the 3909 mark, "I barely even knew the girl. I met her once." So that obviously it's a contradiction. And if he's going to lie, I don't know. If he says never and then once, I don't know. So you usually remember if you've met someone. Therefore, one material and highly relevant contradiction exists. It is therefore plausible that many more contradictions would be available to the defense. So because we've found one contradiction, we can infer that we would find many contradictions, is what their argument is here. Such negligent and intentional conduct on the part of the police has also resulted in the absence of material evidence which would be exculpatory in nature. The circumstance in and of itself violates Richard Allen's due process rights. We must, however, place such conduct in a greater and more noteworthy context. It has also been discovered that former Rushville police officer Todd Click reached out to prosecutor McLeland in an attempt to bring his attention to the existence of an 85-page report summarizing the investigation that revolved around Brad Holder, Patrick Westphal, and other affiliates. This letter, which landed on Prosecutor McLeland's desk via certified mailing on May 1st, 2023, was not discovered to the defense until more than 4 months later, on September 8th, when they got their big data dump, and only after the defense disclosed it in depositions that they were aware of the odinist ties to the crime and investigation. The failure to disclose on the part of the prosecutor is not entirely intentional, if not entirely intentional, rises to the level of an untimely failure of disclosure of potentially exculpatory evidence. The failure to disclose sheds further suspicion on the absence of the Holder and Westphal interviews referenced herein. I agree, and it also makes me suspicious of Prosecutor McLeland if he's going to not turn things over right away, even though he's getting them via certified mail, and he thinks that it's not an 85-page report summary revolving around Brad Holder and Patrick Westphal and other affiliates. He didn't think that was important for the case to turn it over. And it only got turned over in the data dump, probably hoping that they wouldn't see it, because they mentioned that they knew the Odinist ties. So that's curious. Anyways, furthermore, as explained in the Franks memo, it appears as if law enforcement and possibly the prosecutor himself attempted to conceal the identity of a Purdue professor who contradicts the sworn words of Trooper Jerry Holman and Sheriff Tony Liggett concerning whether the crime scene contained signs of the involvement of an Odinist cult or religion or whatever you want to call it. In more recent discovery, defense also located a prepared search warrant application to AT&T for data contained on Brad Holder's and Patrick Westfall's mobile devices. Each application states that Holder and Westfall is, quote, a known member of a religious sect and elements of the unalivings have potential religious significance. The importance between being requested is relevant to an ongoing criminal investigation, end quote. So that they purposely were trying to seize Holder and Westfall's phones specifically to see how they were tied to the, if and how they were tied, because they were a known member of a religious sect. And they already knew, and they specifically say right here, elements of a potential religious significance. But yet they deny it. The state denies it. Or omits that from all of the discovery that they gave to the defense in the very beginning. All right. And they're just getting it now. So the information being requested is relevant to an ongoing criminal investigation. There is no evidence that the warrant was ever served. Also, the defense has not located any discovery regarding any data contained on Holder's and Westfall's 2017 phones or any other electronic devices. It defies logic that law enforcement would conduct forensic examinations of so many other phones in its investigation, yet ignore the phones of Brad Holder and Patrick Westfall, who were viewed as suspects within 3 days of the unalivings and interviewed by law enforcement, who then prepared search warrants for their phones. Good point. These suspicious facts further call into question the circumstances surrounding the destruction of key videotape statements of Holder and Westfall, if they ever existed, and support Richard Allen's motion to dismiss all charges filed by the state of Indiana. It just makes me really think that there's something going on in Delphi. It seems like law enforcement may have some Odinist ties if they have a reason to want to cover it up. Potentially. Allegedly. That's what they're alleging. I'm just reading documents. Don't come at me. Alright, so the defendant requests a hearing at which time he can present evidence and make arguments as to why these charges should be dismissed. The defense files contemporaneously herein with memorandum in support of this motion. So they provided a memorandum of all the case law. So that was, comes now. Richard Allen wants his day in court, and Andrew and Baldwin. Andrew Baldwin and Bradley Rosie signed. He wants the charges dismissed because of the negligence of the law enforcement and the fact that there's potential exculpatory evidence that has been destroyed in this case. Allegedly. All right, so memorandum of law in support of dismissal. So at issue is the purposeful or neglectful failure to preserve and or the destruction of material and exculpatory evidence critical to the defense of Mr. Allen. It also involves the attempted concealment of the identity, to a key witness, later identified as Professor Jeffrey Turcotte. So this is the guy that they were talking about in the Franks memo, a professor that the state said they couldn't find and they may never find them. They couldn't remember who it was. They were going all over the place. But they said, oh, don't worry. They said it's not anything tied to Odinism. That's what they told us. But then when Allen's defense team sent out the Franks, or published the Franks memo, it became, it blew up social media wise, and the professor reached out, I think, to the defense or to whoever, and now we know the identity of that person who originally reviewed the crime scene, and he actually did say that there were signs that it could be tied to some kind of ritualistic or pagan something or other, or some kind of sacrifice. So he said, he said the exact opposite of what the state was saying he said. So, but he came out of the woodwork, thankfully, for us. All right, so Indiana Code 353414A states that this court may, upon motion of the defendant, dismiss an information upon certain grounds. In this case, the defendant requests the court to dismiss this information pursuant to Indiana Code A11, which states that a motion to dismiss an information may be granted for, quote, any other ground that is a basis for dismissal as a matter of law, end quote. Also, such grounds would include a violation of a defendant's constitutional right to due process. Additionally, trial courts have inherent authority to dismiss criminal charges where the prosecution of such charges would violate a defendant's constitutional rights. So they're making the argument then that these charges, because of the way that they were handled, the way that the investigation was done, the way that things were hidden, these charges violate Rick Allen's constitutional rights, and they're stating case law. Matlock. Ooh, Matlock versus state. Okay. See also State versus David. Such grounds would include a violation of the defendant's constitutional right to due process. A motion to dismiss based upon a ground specified in Indiana Code 411 may be made or renewed at any time before or during trial. See Indiana Code 4B. Therefore, that matter is properly and timely raised. The Indiana Supreme Court has held that a serious breach of duty occurs when the prosecution willfully or intentionally, when unjustified by a public policy, obstructs the access of the defense to material evidence in its possession. It is likewise a serious breach when, through lack of vigilance, the negligent destruction of withholding of material evidence by law enforcement officers or prosecutor occurs. In such instances, grounds for reversal may exist. So they're trying to get the charges dropped or reversed or whatever that means. All right, so Indiana Supreme Court has also held that the negligent or intentional destruction of evidence by the police can provide grounds for reversal or dismissal on due process and due course of law grounds. So they're stating a whole bunch of other case law. So all this is basically case law supporting their motion to dismiss. And what's likely going to happen is the judge is going to deny their motion to dismiss. But they needed to make this motion to put it on the record and to make sure that Richard Allen's constitutional rights are protected going forward if and when we go to trial, and if and when he is found guilty and may have to appeal his case. So, prior to any request for discovery by the defendant, the negligent destruction or withholding of material evidence by the police or the prosecution may present grounds for reversal, according to Burke law. The Indiana State Court has further held that when the prosecution determines evidence to be non-material and further decides not to advise defense counsel of such evidence prior to its destruction, a heavy burden rests upon the prosecution to demonstrate that the destruction of such evidence did not prejudice the defendant. So their attorneys, Richard Allen's attorneys, are quoting this case law stating, so now that this evidence or exculpatory evidence that could have gotten my client off is missing, you have to prove that the prosecution has to prove that it wasn't exculpatory evidence. You have to prove that whatever was on those recordings that are now deleted wouldn't have hurt my client, or, wouldn't have helped my client. So you need to prove that. And it's a higher burden. Now you have to prove that my client's guilty, but you also have to prove that the evidence that's missing or deleted wouldn't have helped him or prejudiced him in any way. All right, so the appropriate test to apply when deciding whether a defendant's due process rights have been violated by the state's failure to preserve evidence depends on whether the evidence in question was potentially useful evidence or material exculpatory evidence. It comes from Blanchard versus State. The burden is on the state to demonstrate that the evidence was not material and its destruction did not prejudice the defendant. Potentially useful evidence is defined as evidentiary material of which no more can be said than that it could have been subjected to tests, the results of which might have exonerated the defendant. The state's failure to preserve potentially useful evidence constitutes a due process violation when the defendant can show bad faith. The Seventh Circuit has held that bad faith may be inferred when a party disposes of evidence in violation of its own policies. So their own policies in the law enforcement, I'm sure, is not to record over statements. So they violated that. Violation of a record retention regulation creates a presumption that the missing records contained evidence adverse to the violator. The bad faith presumption arises when the failure to retain records or other evidence actually violates the terms of the applicable policy. However, the Indiana Court of Appeals has noted that in some instances, the destruction or failure to preserve evidence may be so prejudicial to the defendant as to warrant reversal, even in the absence of bad faith by the officers. So even if it wasn't totally on purpose that these interviews got recorded over, it's still the fact that the state failed to preserve the recordings is enough to be prejudicial or to warrant a reversal or dismissal. Material exculpatory evidence, on the other hand, is defined as evidence that possesses an exculpatory value that was apparent before the evidence was destroyed and is of such a nature that the defendant would be unable to obtain comparable evidence by other reasonably available means. So he has no other interview of Brad Holder out there to compare it to get. There's no other first interview of Brad. That was his first interview, and now it's gone. You can't get that back. So the state's good or bad faith in failing to preserve material exculpatory evidence is irrelevant, whether they did it on purpose or not. The Indiana Supreme Court has held that the defendant must establish materiality as a condition precedent to claiming a denial of due process where evidence is negligently lost or withheld by the government, except where the materiality is self-evident or a showing of materiality is prevented by the destruction of the evidence. An item is material if it appears that it might benefit the preparation of the defendant's case or if it might reasonably affect the outcome of the trial. So that's what makes it material. If it could benefit the preparation of the defense, or it might be it could reasonably affect the outcome of the trial. That's material evidence, according to this definition. In this matter, given the nature of the evidence that law enforcement either failed to preserve or actually destroyed, the materiality was and is self-evident. Furthermore, as in Lee, the failure to preserve or destruction prevents the defense from establishing the exculpatory nature of the evidence and its materiality. They can't even establish if it was exculpatory because it doesn't exist. As such, Allen is not required to demonstrate the materiality of the evidence. To be sure, the unavailable evidence had exculpatory value, which was apparent at the time it should have been preserved and prior to its destruction. Additionally, Allen is unable to obtain comparable evidence by other reasonably available means. Spoliation of evidence is the intentional destruction, mutilation, alteration, or concealment of evidence. If spoliation by a party to a lawsuit is proved, rules of evidence permit the jury to infer that the missing evidence was unfavorable to that party. So if it is proven that these officers or McLeland or whoever was responsible somehow recorded over their Brad Holder and Patrick Westfall's recordings on purpose, if it's proven that it was intentional, then the jury could infer, they can make the reference that all the evidence on there was unfavorable to the party that submitted it, so the prosecution. Even if this court requires a showing of bad faith, it is apparent. Bad faith is defined as being not simply bad judgment or negligence, but rather implies the conscious doing of wrong because of dishonest purpose or moral obliquity. Obliquity is defined as deviation from moral rectitude or sound thinking. Deviation from moral rectitude and sound thinking. The United States Supreme Court has recognized that the police have a constitutional duty to preserve such evidence. In Trombetta, the Supreme Court observed that whatever duty the Constitution imposes on the states to preserve evidence, that duty must be limited to evidence that might be expected to play a significant role in the suspect's defense. The court recognized that same duty in Arizona versus Youngblood, confirming that the Constitution imposes at least a limited obligation on the police to preserve evidence that could form the basis for exonerating the defendant. So they do, Arizona versus Youngblood also found that the police, law enforcement, have a duty to preserve evidence, even if it's exculpatory to the person that they do end up claiming to be their suspect in the crime, the perpetrator. Sorry, dog. Just gotta get cozy and comfy. All right, so it is beyond debatable that the evidence at issue here would play a significant role in Mr. Allen's defense and would form a basis for exonerating him. Additionally, the suppression by the prosecution of evidence favorably to an accused upon request violates due process where the evidence is material either to guilt or to punishment, irrespective of the good faith of the prosecution. To prevail on a Brady claim, a defendant must establish 1. That the prosecution suppressed evidence, and 2. That the evidence was favorable to the defense, and 3. That the evidence was material to an issue at the trial. Indiana Constitution. It is clear that the federal Constitution is not the sole guarantor of the right to due process and other rights. Chief Justice Shepard made this abundantly clear in his law review article, Second Wind for the Indiana Bill of Rights, when he stated in conclusion that civil liberties protected only by a U.S. Supreme Court are only as secure as the Warren Court or the Rehnquist Court wishes to make them. The protection of Americans against tyranny requires that state Supreme Courts and state constitutions be strong centers of authority of the rights of the people. I am determined that the Indiana Constitution and the Indiana Supreme Court be strong protectors of those rights. So the Chief Justice also stated that in Indiana was Indiana was an early and noteworthy participant in using its Bill of Rights to defend personal liberty, and after citing to numerous early decisions, noted that these but a few in a fine line of cases in which the Indiana Supreme Court held that the Indiana Bill of Rights afforded Hoosiers rights which the federal Constitution did not. Chief Justice Shepard also made note of the fact that many provisions of the Indiana Bill of Rights have no counterpart in the United States Constitution and observed that Article 1, Section 12 was one of those provisions. This provision relating to due process is at issue in the instant case. The Due Process Clause of the United States Constitution is found in Section 1 of the 14th Amendment to the Constitution. That section states in relevant part that no state shall make or enforce any law which shall abridge the privileges or immunities of citizens in the United States, nor shall any state deprive any person of life, liberty, or property without due process of the law. All right, so the right to due process conferred under the Constitution of the State of Indiana is found in Article 1, Section 12, and contains significant language not found in the Constitution of the United States. The provision states, all courts shall be open, and every person for injury done to him in his person, property, or reputation shall have remedy by due course of law. Justice shall be administered freely and without purchase, completely and without denial, speedily and without delay. While the defense is unaware of any Indiana case law specifically interpreting the emphasized portion of this constitutional provision, the provision itself was traced back to the Magna Carta in Board of County Commoners versus Larimore. The Larimore court also acknowledged that although the provision was derived from the Magna Carta, it may be a broader guarantee of free, unpurchased, and impartial justice. Three more contemporary decisions dealing with the issue of destruction of evidence are of particular import. First, it is clear from Chief Justice Shepard's occurrences in House v. State that the issue of whether a lack of good faith on the part of the state was required for a defendant to obtain remedy for the destruction of potentially exculpatory evidence under the Indiana Constitution has not been decided adversely to the defendant, even after Young. So that has not been decided in Indiana law. The House decision actually dealt with the discovery of potentially exculpatory evidence and the need for materiality and that evidence. Both Chief Justice Shepard and Justice DeBruler, however, discussed the related issue of destruction or loss of such evidence in his concurrence and dissent. Justice DeBruler stated, "While I agree with the result reached by the majority opinion on this discovery issue, I point out that when the accused shows that material evidence was in the hands of the prosecution and lost, the question of whether the accused must then go ahead and show prejudice is open in Indiana. In my judgment, when the item is not available for scrutiny by the trial court, but is known to have been material, the risk of loss should be borne by the prosecution, not the defendant." So the risk of losing, the risk of your case is based, could be hinged on that material evidence that we will never know about because it's missing. The police and prosecutors are, after all, highly trained specialists in the gathering and retention of evidence and should be expected to carefully retain all material evidence in usable form. So the fact that they didn't is in and of itself just flat out negligent. They should know how to keep copies of recordings of interviews, especially for suspects of a very brutal crime. All right, so Chief Justice Shepard, in his concurrence, stated that I agree with Justice DeBruler that this case does not decide what standard Indiana should use for cases in which the prosecution has disposed of arguably material evidence which might exculpate the defendant. The instant case certainly appears to be the type of envisioned by these comments. 2 Indiana decisions have been found in which the issue of due process and the destruction of evidence was raised under both the federal and Indiana constitutions. Hale versus State and Douglas versus State. Although both of these decisions were determined adversely to the defendant based on the facts of the cases, both also stated that negligent or intentional destruction of material evidence by the police or the prosecution may present grounds for reversal. In each case, the defense alleged a violation of due process under both the federal and state constitutions. While both decisions were rendered prior to the United States Supreme Court's decision in Youngblood, the decision in House rendered after the Youngblood decision makes it clear that the principle announced in Hale and Douglas may still be valid under the Indiana Constitution. Additionally, Lee Supra was decided after Youngblood. All right, so in the language of Article 1, Section 12 of the Indiana Constitution, justice shall be administered freely and without purchase, completely and without denial, speedily and without delay. Is to have any meaning at all, it certainly seems to support a more stringent enforcement of due process rights than required under the federal Constitution. Given the facts of the instant case and penalty involved, and the long history of concern about preservation of evidence in Indiana case law, as well as evidence of attempts of law enforcement and the state of Indiana attempting to conceal other material and exculpatory evidence, Mr. Allen should not be deprived of a remedy for the egregious loss of evidence occasioned by the actions of law enforcement and or the prosecution in his case, especially in light of the case with which the evidence could have been preserved. The only remedy that serves the interests of justice and guarantees Mr. Allen's constitutional rights is dismissal. That was written by Andrew Baldwin and Bradley Rossi, and certified on the 7th of February, so just yesterday. So there we have it. Those are all of the filings from yesterday regarding Richard Allen's defense team. They submitted a motion to dismiss and all the case law reasons why. What do you think? Let me know in the comments below if you think, based on this argument, based on all the case law, that Richard Allen deserves for these charges to be dropped, or do you think it's not enough? What do you guys think? I really would love to know. Let me know in the comments below. Thank you so much for sharing your time with me and reading this through with me, and have a great day. Thanks for watching. Bye.